Hi, everyone. I'm Paul Coble, Chair of Intellectual Property and Artificial Intelligence at Rose Law Group. And I have a big update for you today on copyright and whether it constitutes fair use to use a copyrighted work to train an AI model. This update comes from a ruling in the case Thomson Reuters versus Ross Intelligence, currently playing out in the District of Delaware. Thomson Reuters owns the popular service Westlaw, which publishes judicial opinions, along with a variety of commentary and summaries of the cases. And it's actually those case summaries called headnotes that are at the center of this opinion. You see, Ross did not just copy the judicial opinions, which are not actually protectable by copyright at all. But Ross also did not copy directly the Westlaw headnotes. You see, instead, Ross hired a bunch of attorneys to summarize the opinions in memos and instructed those attorneys to draw heavily from the Westlaw headnotes. In fact, the court noted that several of the Ross opinion memos more closely resembled the Westlaw headnotes than the cases themselves. This week, the court ruled on summary judgment that Westlaw's headnotes are protectable by copyright and that Ross's use of those headnotes to train a competing AI model violated Thomson Reuters copyright. This ruling is important for creatives and anyone using copyrighted works to train AI models for a couple of reasons. First, the court recognized that a copyright can exist in the subjective summary of something that would otherwise be unprotectable. As I noted before, judicial opinions as public records are not ordinarily subject to copyright. This is the same for things like facts and data and ideas. Those types of works, no matter how presented, are not typically subject of copyright. However, the court recognized that there could be some elements of creativity imparted by the humans that are doing the summaries of these cases, and those creative elements may be subject to copyright. This is important because more and more products out there are essentially insights that are helping us to interpret otherwise unprotectable facts and data. And this ruling is going to provide increasing support to protect those types of derivative products. The second reason, perhaps more interesting, why this ruling is major in the field of artificial intelligence is because for the first time, a federal court has held decisively that using a copyrighted work to train an artificial intelligence model for competitive purposes is not fair use. Court here conducted an exhaustive analysis of the 4 statutory fair use elements and found that 2 of the elements favored the defendant Ross and 2 of the elements favored plaintiff Thomson Reuters. But the 2 elements that favored Thomson Reuters were the most important, traditionally found to be the most important factors. And that is the transformative nature of the use and whether the use is usurping a competitive or is anti-competitive in nature with the copyrighted work. And here, the court found that it is so clearly weighted in the side of the plaintiff that Ross's use of the Westlaw headnotes were not transformative. They were being used for the same purpose, otherwise providing insight into the case opinions. And they were being used for a competitive purpose. And those factors weighed so heavily in favor of non-fair use that the court found that no reasonable jury could find that Ross's use here constituted fair use. Of course, this opinion is likely to be appealed, but for now, the assumption should be that training an artificial intelligence with copyrighted works is not fair use, at least not when deployed in competition with the original copyrighted work. Stay tuned to Rose Law Group for more artificial intelligence and technology news. Thanks for watching.